When most people hear the phrase sexual harassment, they think of inappropriate comments, unwanted advances, or stories that have appeared in the news. However, sexual harassment is more than a social issue. It is also a legal issue that has shaped women's ability to participate equally in the workplace. My position is that sexual harassment law has been one of the most important legal developments for women's equality because it's transformed harassment from something that was often ignored into a form of unlawful discrimination. While these laws have created important protections, many women still face challenges when reporting harassment and seeking justice. The values that support my position are equality, dignity, workplace safety, and equal opportunity. No one should have to choose between keeping their job and tolerating harassment. Today, many people assume sexual harassment has always been illegal. However, that was not always the case. Before the 1980s, workplace harassment was often dismissed as a personal matter rather than a legal one. Women who experienced harassment frequently had little recourse and were often expected to simply tolerate inappropriate behavior or leave their jobs. A major turning point came in 1986 with a Supreme Court case called Meritor Savings Bank versus Vinson. So Meritor Savings Bank versus Vinson. This case involved a woman named Michelle Vinson. Vinson worked for Meritor Savings Bank and alleged that she had been subjected to repeated sexual harassment and abuse by her supervisor. At the time, the question before the Supreme Court was whether sexual harassment could be considered discrimination under Title VII of the Civil Rights Act of 1964. The court ultimately ruled that sexual harassment could constitute sex discrimination. This decision was groundbreaking because it established the concept of a hostile working environment. In other words, discrimination was no longer limited to hiring decisions, promotions, or wages. A workplace could also be discriminatory if harassment was severe or pervasive enough to interfere with an employee's ability to do their job. This case changed the legal landscape for women across the country. For the first time, the Supreme Court clearly recognized that harassment itself could be a form of discrimination. And the significance of this ruling goes beyond one woman's experience. Sexual harassment can affect a person's mental health, job performance, and economic opportunities. Women who experience harassment may avoid promotions, leave jobs, or leave entire professions. When people are forced out of workplaces because of harassment, equality becomes impossible. This is why I believe sexual harassment law is fundamentally connected to women's rights. Equal opportunity means very little if people are unable to work in an environment that is safe and respectful. Case number 2. Farringer versus City of Boca Raton. The next major case occurred in 1998, not too long ago. In Farringer versus City of Boca Raton, a female lifeguard alleged that she was subjected to repeated harassment by supervisors. The Supreme Court ruled that employers could be held responsible for harassment committed by supervisors under certain circumstances. This decision was important because it shifted some responsibility away from victims and towards organizations. Instead of simply expecting employees to deal with harassment on their own, employers were encouraged to create policies, reporting systems, and training programs designed to prevent harassment before it occurred. The case reinforced the idea that workplace equality is a shared responsibility. Case 3. Burlington Industries versus Ellerth. Also, not that long ago, in 1998, the Supreme Court decided Burlington Industries versus Ellerth. Kimberly Ellerth alleged that a supervisor repeatedly made unwanted sexual advances and suggested that her career opportunities depended on how she responded. The court ruled that employees do not necessarily have to suffer direct economic consequences, such as being fired or demoted, in order to bring a harassment claim. This was another important step because it acknowledged that power and intimidation can affect employees even when no official punishment occurs. Harassment can create fear, pressure, and emotional harm long before somebody loses their job. The opposing arguments, I guess, would be not everyone agrees that current sexual harassment laws are appropriate. One argument is that false accusations can unfairly damage a person's reputation. While false accusations can happen, and they do, research generally indicates that they are relatively uncommon. A larger problem is underreporting. Many victims never report harassment because they fear retaliation, embarrassment, or professional consequences. Another argument is that workplace rules have become too restrictive. Some people worry that ordinary interactions could be misunderstood as harassment. However, the legal standard is much more narrow than many people assume. The law generally focuses on conduct that is severe or pervasive enough to create a hostile work environment. The goal is not to regulate normal social interactions, but to prevent discrimination and intimidation. Looking forward, I believe sexual harassment law will continue to evolve. The hashtag #MeToo movement increased public awareness and encouraged more people to speak out about experiences that had often remained hidden. Future legal issues may involve online harassment, remote work environments, and new forms of workplace communication. Courts and lawmakers may also focus more heavily on intersectionality, recognizing that women of different races, socioeconomic backgrounds, and identities may experience harassment differently. The challenge moving forward will be balancing due process protections with meaningful support for victims. So, in conclusion, sexual harassment law represents one of the most important developments in the fight for women's equality. It is. Cases such as Meritor Savings Bank versus Vincent, Farringer versus City of Boca Raton, and Burlington Industries versus Ellerth transform the way the legal system views workplace harassment. These decisions establish that harassment is not merely a personal problem. It is a form of discrimination that can limit opportunities, undermine dignity, and prevent equal participation in the workplace. Although legal protections are not perfect, they remain an essential tool for promoting equality and ensuring that workplaces are safe and fair for everyone. Thank you.